It's not often that we have a sexy bill such as this that comes up that people are dying to speak on. But I note that my colleagues are saying that this bill provides a balance between encouraging competition in the innovative compound market and encouraging registration of innovative products. I also note that this will give our primary sector productivity an international competitiveness edge. Now that's where I want to ask the Minister a couple of questions. You see, we have realm countries who are part of the Pacific, Niue, Tokelau, and the Cook Islands. I want to ask the Minister, does this bill apply to these countries? Does this new legislation apply to these countries? If so, I then want to raise the concern that I have, sir, because if we're providing an additional 3 years of protective to new innovative compounded trademarks for new compound, my question is, sir, is there protection for Pacific intelligence when it comes to the use of certain compounds, certain medicine, certain plants? You see, soursop, for example, and the use of papaya has international recognition. And I'm saying that is used freely by the Pacific. And so I'm asking the Minister, would she be prepared to sort of shine some light whether, firstly, whether this bill applies to those realm countries, and secondly, what protection do those countries have in terms of their intellectual property, because the islands use these plants, fruits, free. Here we're looking at protecting the trademarks of compound that have been produced for profiting. You know, that's why we're extending from 5 to 8 years of protection for new innovative findings. But I want to know, does that then extend? See, in the Pacific, papaya is used regularly by the Cook Island country. And I understand that in the leaves, the fruit are also, if boiled, has a certain, provides a certain relief to people who have cancer. Soursop, and there's material on the international market, soursop is also used by local medicine people. Now that is offered for free. There is no money made by the people who use this. But here we're looking at protecting the rights of certain companies to come up with new innovative design, whatever. But this is about protecting their profit margins. It's protecting their rights to be able to sell this on the international market. Okay, well then correct me. How does this apply to the Pacific? How does it apply to intellectual property that is owned by the Pacific, practiced by the Pacific, and is freely available, has no protection whatsoever? So, you know, I hope the Minister can do it, because I'm not on the Select Committee, but I've been officially appointed tonight to speak on this. You know, I didn't want to speak on it, but I was asked to speak on it, and I'm delighted with the opportunity that I can now ask the Minister, because I was dying to get on that Select Committee. I put my hand up 5 or 6 times to the whips to get on this Select Committee, but now that I've got this opportunity, will the Minister take the opportunity to enlighten this House, particularly myself from the Pacific? There are at least 7 others, 9 others on all sides of the House who would be interested in how this bill would protect the intellectual property that are owned, that aren't recorded anywhere in the Pacific, but are freely distributed for the sake of providing well-being, health protection to a range of people in the Pacific, and will those be protected under this legislation? And what happens if nobody comes forth from the Pacific to protect that intellectual property? Will it be recognised?
The Honourable